Great. Thanks, Alyssa. So it's great to be back with you all again this morning. Again, my name is Stephanie Ertis. I'm the Associate Director at MCASA. And I usually don't pop into this presentation, but maybe some of you will relate to the fact that our usual Sexual Assault Legal Institute attorney who does this training for us recently left the organization and we are working to fill her position. So for the first half of this training, we have the recording of Natalie doing this presentation, providing this information. So we're going to play that recording for you this morning. And then if there are any questions related to the legal content she's talking about, Alyssa will collect those in the chat, or you can come off mute at the end. And we will have one of our attorneys address those and we'll send it out in the email. It's a thorough presentation, so she's going to give you a lot of good information. This is going to be really relevant to folks that may be ending up doing legal advocacy. So if you aren't planning on doing legal advocacy, it's still going to help you understand some of that legal process. So again, at the end, if you have questions about any of the work that the Sexual Assault Legal Institute does or legal options, you will have a chance to ask those and we will collect them for one of our attorneys to answer. So thank you in advance for being patient with us. Maybe some of you have worked at organizations that have had some turnover. And we wish Natalie the best. She moved on to a great position for her. So I will begin our video and then we'll pause in the middle, ask questions, and then we'll start the second part of our presentation.
Legal Institute, or SALI, which is the legal arm of MCASA. I'm honored to be able to present to you all today. Today's topic we'll be covering is ethics, confidentiality, and advocate testimony. So we'll go ahead and just dive right in. Okay, so our objectives for today. By the end of today's presentation, you will be able to define what is confidential versus what is privileged information. You will be able to decide when to release client records. You'll know the difference between an expert witness and a fact witness. You should feel more comfortable testifying in court. And we hope that by the end of today's presentation, you will know how not to commit the unauthorized practice of law. So first, we're going to talk about confidentiality versus privilege. So they're similar, but there are some important distinctions. Confidentiality protects a survivor from disclosure of communication between professionals and a competent client or patient to any third party in any context. Privilege also protects the survivor from disclosure of communications between a professional and a client or patient to third parties in any context, but it also protects disclosure from being made in court or in depositions. So the main difference is that privilege protects a survivor from communication being disclosed in a court context. Privilege is a higher or a stronger protection than confidentiality. All privileged information is confidential. So that means all information that is privileged, you cannot share with a third party or in court, but not all confidential information is privileged. So there's some information that you can't disclose to a third party, but may be required to be disclosed in a court context if there's a subpoena requiring you to do so. So who is covered by confidentiality and privilege? You'll see that there is some overlap. Confidentiality covers medical providers, mental health providers, advocates, attorneys, and then some grant recipients. Privilege also covers mental health providers and attorneys, but it also has coverage for clergy, spouses, and privilege covers self-incrimination. So there's a clergy parishioner privilege that prevents clergy from testifying about information that one of their parishioners may have shared with them There's a spousal privilege that prohibits spouses from testifying against each other in court. And there's also the privilege of to be saved from self-incrimination. So you aren't required to testify against yourself in court. So where did this protection come from? Again, you'll see that there is some overlap, but there are some differences. Confidentiality often comes from professional rules of ethics, professional licensing rules and regulations. Oftentimes, organizations have internal policies related to confidentiality. Also, a lot of grants that many of us, I believe, are covered by, such as VAWA and VOCA, have specific regulations and reporting or confidentiality requirements. And then finally, confidentiality may come from state or federal law. Privilege comes from the law. So privilege can be found in statutes, state law, as well as federal law. So I want to talk a little bit more about the Violence Against Women Act, because I know a lot of us work under VAWA. So this is directly from the statute. It has its own confidentiality protections, and the language of the statute reads, in order to ensure the safety of an adult, youth, and child victims of domestic violence, dating violence, sexual assault, or stalking, and their families, grantees and subgrantees under this subchapter shall protect the confidentiality and privacy of persons receiving services. So that's the language of the statute that serves as a confidentiality protection for recipients of VAWA. There are no exceptions for this for grant reporting. So I want to remind everyone to take care when you're using examples in your grant reports to make sure that you are adhering to the confidentiality provisions. There are also no exceptions for collaboration. So when collaborating with other organizations, you also want to be careful that you are not violating the confidentiality provisions of VAWA. There's also no internal data sharing under the provision, and you may not require sharing as a condition for providing services. So when you're intaking a client, when you're speaking to a client at the beginning of your relationship, you cannot require a client to waive this confidentiality as a condition of providing them services. One important distinction is that in certain situations, a parent or guardian can provide for the release of information for an unemancipated minor, but it's very important to note that if the parent is the alleged abuser, this does not apply. So alleged abusers who are parents cannot provide the release of information to the organization. So another important distinction is that the VAWA provisions are not privilege. They are confidentiality provisions. So that means you're prohibited from sharing information with third parties, but the VAWA provisions do not protect against court orders and subpoenas. So you can be required to disclose information in court. If there is information that must be disclosed per a subpoena, VAWA does require, however, that the providers attempt to notify the client beforehand. Oh, sorry. One more thing that I want to note about this is that while VAWA is not a privilege requirement, depending on the services that you are providing or that a survivor is seeking, there may, however, be privilege invoked. For example, if you provide legal services and the client is communicating with an attorney at your organization, that would invoke the attorney-client privilege. So although VAWA does not provide privilege, there may be privilege under other situations or relationships you have with your client. But VAWA itself does not create the privilege. So a little bit more information about confidentiality versus privilege. In both scenarios, the privilege or the confidentiality belongs to the patient or client, not the advocate. That means that in general, it's only the patient or the client who can waive the confidentiality or privilege and can give consent for their information to be released. There are a few exceptions to that. One of the exceptions is in the case of mandatory reporting of child abuse or abuse of a vulnerable adult. I would recommend that everybody consult with your organization or an attorney to find out if you are a mandatory reporter underneath the law of your state that you're practicing in. Not all service providers are mandatory reporters. For example, me as an attorney, I am not a mandatory reporter, but many of you working in different vocations may be. Another exception for this general rule is that people under 18, their parents may be the ones who are able to waive confidentiality or privilege, especially in the case of minors who are not emancipated. And then there are other exceptions that vary based on profession. For example, in the mental health profession, if a patient is a threat to their self or others, there may be an exception for reporting that information, or in the medical profession, or there may be an exception for malpractice claims. So you always want to check with legal counsel to make sure that you are under the law and following that correctly. All right, another important thing to note about confidentiality and privilege waiver is that it's all or nothing. So you can't just waive confidentiality to release some information, but choose to keep confidential other information. So I'm going to give an example, and this is a trigger warning. It does mention physical and sexual abuse. But here's the example. It says, Maria wants the rape crisis advocate to give expert testimony that Maria's husband physically and sexually abused their 6-year-old daughter, but not that Maria waited a month to go to the police after she found out. So this would not be possible. If Maria chooses to waive confidentiality or privilege, the advocate would be open to testimony on all of that information, not just the information about the abuse perpetrated by her husband. So that is something that you want to talk to your client about before they decide to waive confidentiality or privilege, that they can't just pick and choose the good facts to waive confidentiality for. It's an all or nothing choice. So why do we have privilege and confidentiality? It's designed to help people seek out services. If people think that information that they share is discoverable, they are often less likely to seek services, which could cause them more harm because issues are not addressed. It also protects children to have that confidentiality in place. And also, it was a choice by the legislature in light of the constitutional right to confront witnesses. So defendants in trials have a constitutional right to confront witnesses and ask them questions throughout the trial. But the legislator created privilege because they believe that certain types of professions or relationships should be protected from this type of disclosure. For example, they don't want attorneys or clergy members to be drawn into court and forced to testify about their clients or parishioners. That brings me to Uber privilege. So there are certain records that are given an Uber or super privilege. These are specifically records of attorneys or clergy. They are very, very hard, if not impossible, to obtain because they are so protected. But other records that are privileged, like mental health or social worker records or medical records, may be easier to obtain, especially in criminal or custody cases. because they are more likely to be relevant to the case, and any damage that may be caused from breaking the privilege is seen as less important than the damage that might be caused if an attorney or a clergy was forced to testify. So why and when should an advocate release confidential client records? You need a written release from the survivor, from your client. We recommend that when you do get this written release, you should use a HIPAA compliant model release. Most of your organizations should have one of these that they use as a template. So you want to make sure that you have a written request or a written release, I'm sorry. You also want to make sure if there's an attorney requesting information, for example, to use in a peace order or a family law case, this also includes a written release from the survivor. If there's a request from a state's attorney or a subpoena, you want to make sure that it comes with a written release. You may also be asked to release confidential records from a subpoena from the perpetrator's attorney, so from the defense counsel. And then there also may be a court order that would cause you to release records that are confidential. So when you're responding to a release for records, this is kind of the steps that we recommend you take to make sure that you're practicing in a survivor and trauma-informed manner. You want to first have a conversation with your client and see what they want. Do they want to keep the information confidential? Do they want to stop it from being disclosed? Or are they okay with it being shared? You also want to make sure that you have informed consent. So that looks like going over the pros and the cons and explaining what the results of releasing the records could be. You also obviously want to make sure that the release, if given, is voluntary. And like I said before, you want to make sure it's a written release that's made voluntarily and not made because the client believes that they have to sign this release in order to receive services. You want to make sure that they understand what they're doing when they sign it. And then I've said it a bunch of times, but you want to make sure that that release is written. So you want to make sure that you're using, as I said, a HIPAA compliant model release, and there are some special requirements depending on the type of records being released. For example, here's a list of specific types of record that require a specific release. So you want to look to state or federal law to see what the release requires for these types of records. So for drug treatment records or records about somebody's HIV or AIDS status, this requires a very specific release. And another unique situation is other providers' records. So for example, you may be requesting records from one provider, but within their records, they have information from another third-party provider. So it's kind of two levels of confidentiality that you'll need to address separately and make sure that you have releases for both levels of those records. Also, in your releases, you want to make sure that they're reasonably time limited. You don't want them to extend forever. So for example, we recommend a 1-year time limit that the release extends for until it expires. We always recommend not accepting releases from other agencies, but rather drafting your own release so that you know exactly what it says and exactly what it provides. And as I mentioned before, a conversation with your client is very important. So we would recommend requiring a conversation with your client before releasing any records, just to ensure that the release is voluntary and that there has been informed consent. So here are some of the, as I mentioned earlier, you want to go over the pros and cons with your client before releasing records. And here are some of those pros and cons. On the pro side, Advocates' records may be very important evidence used to support the survivor's or the state's case against a perpetrator. Also, a survivor's refusal to waive confidentiality may lead the court to infer that records would be damaging to a survivor or a state's case. So they could assume that because you're not willing to release records, there's something bad in them. So that would be a reason that you may want to release the records. A con to releasing records is that obviously there's a loss of privacy for the survivor. And as I talked about earlier, it's a total waiver. So survivors cannot pick and choose what parts of the records to release. If you release the record, everything in the record is then open for view and to be looked over and potentially used in the trial. So what do you do if you receive a subpoena? And I'm going to stress this, always want to recommend notifying your supervisor, your executive director, or your legal counsel immediately. So like as soon as you receive it, let them know. It's very urgent because there are certain things that can be done if you receive a subpoena to potentially fight against the subpoena. So with that, when you receive a subpoena, you do not want to turn over the records, even if the person with the subpoena tells you to. You don't want to do it right away because there are legal ways to argue against a subpoena, which I'll talk about in a moment. You also want to find out what the survivor wants. So after you notify your legal counsel or supervisor, you want to have a conversation with your survivor and your client about what they want. Explain to them what the subpoena is, what it's requesting, and talk through the pros and the cons. So there are some special requirements for subpoenas. So in criminal cases, the defense counsel must notify the victim and the prosecutor of a subpoena for medical records. Under HIPAA and state law, there is required notice to a patient and a reasonable time to file something called a motion to quash when healthcare records are involved. And financial records also require notice of a subpoena. So I'm going to talk a little bit more about the motion to quash here. When you are responding to subpoena, you need to get in contact with the lawyer. If you receive a subpoena, the lawyer will likely need a copy of the subpoena or the order, a copy of the records that the subpoena is seeking to be released. You'll want to give your service provider credentials, your supervisor's credentials, any grant supporting services, and then the date that the records or testimony is required to be released by. You want to give all this information to the lawyer because there's a chance that the lawyer can file something called a motion to quash, and there is a time limit to do so, which is why the urgency is so necessary. But a motion to quash is essentially a motion that requests that the court state that the information requested does not need to be disclosed and is protected. So a defense counsel may be requesting these records. If you file or the state's attorney files a motion to quash, that would be and the judge were to rule in favor of your motion, the judge would be saying that no, these records should not be released. They are protected, they are privileged, and the defense does not get access to them. That's why it's so important to contact legal counsel and to not give any records away at first, because there's a chance you don't need to, and you don't want to accidentally give information that is privileged. So that's why we always recommend speaking with legal counsel first. All right, moving on to the next section of our training today. We're going to talk a little bit about advocate testimony. So this is a screenshot from the movie My Cousin Vinny. It's a great film. We included this because it's a great example. This scene specifically is a great example of, I would say, expert testimony given in a trial, in a criminal trial. So what is advocate testimony? There's two types that I want to talk about. One is an expert witness testimony, and one is a fact witness testimony. So expert witnesses can help educate the judge or the jury about domestic violence and sexual violence, and generally can offer expert opinions about a specific case. They have some specific or special knowledge that the average person does not have, and they are specifically trained in the field and have thus expert opinions to offer. A fact witness can only testify from their personal knowledge. So information or facts that they've specifically and personally observed. This means that they can testify to personal knowledge of services provided to a specific survivor and how that survivor may have responded to the services. Advocates can often serve as both types of witness, as an expert or fact witness. So for expert testimony, unfortunately, in our legal field, a lot of judges and juries are still very uneducated about the complicated intricacies of trauma and the cycle of abuse. And so an advocate may provide really helpful information about the cycle of violence or delayed reporting or the effects of trauma on a survivor, and can help educate the judge or the jury about what this means and what it might look like. For a fact testimony, the advocate might be able to provide observations about the specific client, or observations about the opposing party, or observations about interactions between a parent and a child. So when you think about testifying, you also want to think about your records. So you always want to keep your records in the way that you maintain them with an eye towards future subpoenas. So you want to keep them and notate them in a way that gives context for potential bad facts, because it's better to have it all written out in the record than to have to explain it later on the witness stand. So I'm going to give another example. This is another trigger warning. It references sexual assault. So for example, if you're writing a report about your client, instead of writing client appears to be an alcoholic, you might want to consider writing something like, as is typical for many sexual assault survivors, the client self-medicates with alcohol. So instead of just stating the observation, you're giving a lot more context for the situation and for the observation. That would be very helpful for a judge or a jury to hear and see. And it might also prevent you from being necessary to testify if your records explain it already. So why might you want to testify as an advocate? Some of the pros versus the cons again. On the pro side, we have an advocate as a fact witness can help to corroborate a survivor's version of events. So you might have really helpful information to corroborate a survivor's story. An advocate as an expert might be able to explain the survivor's behavior, minimize victim blaming by a judge or jury, and again, explain some difficult concepts or theories that the judge or the jury might not previously understand. Some cons, obviously, it is a loss of privacy for a survivor, which we talked about earlier, you will want to address with your client before agreeing to testify. You also are subject to cross-examination by the perpetrator's attorneys. So that means that they will be asking you questions and you'll have to answer them. There's also a lot of limitations, especially for fact witnesses, based on the rules of evidence. So there's something called hearsay. So you can't testify to, generally, there are some exceptions, but generally you cannot testify to what somebody else tells you or something, or what you hear. You can only testify to what you observe personally. So there are some limitations in your type of testimony because of that. We want to give some advice on what to do when you are preparing to testify. You want to review your records, but only if you're advised to by counsel. You want to provide your resume or your CV if testifying as an expert. We recommend not using your home address. You want to use your office or organization address on your resume or CV. You also want to make sure that your resume or CV is up to date and includes all your relevant experience, training, professional licensure. If appropriate, you also want to talk to the attorney calling you as a witness about what he or she plans to ask you, or your attorney may prepare you to testify as well. So I want to give some tips for testifying. First off, you want to stay calm. It can be very stressful. It is a very unique experience of public speaking. It can feel very adversarial. So you want to make sure that you stay calm, practice some deep breathing before you get started. You want to make sure you answer only the question asked. So the way that testimony works is it's question and answer. So the attorney will be asking you a specific question, and you want to pay attention that you're only answering that question and not giving more information than is necessary. I always recommend, taking a second to actually think about what was asked of you before answering. We also recommend not guessing. It's always okay to say, I don't know, or I do not recall at this time. That is actually way better to do than guessing and giving an answer that later turns out to be incorrect. It would look really bad and potentially be very damaging to your credibility and testimony if you give an answer that is later proven to be false. It's much better to just say, I don't know. You don't want to play lawyer, so you don't want to make arguments or objections. You just want to ask the questions that answer the questions that you're asked. And then finally, you want to talk directly to the judge, or if there's a jury, talk to the jury. So the lawyer will be talking to you and asking you the questions, but you want to make sure that your turn to face the jury or the judge. You're not telling the story to the lawyer. The lawyer's there to act as a tool to move the narrative along, but you're actually giving the information to the jury. So you want to make eye contact and look at the jury or the judge. Some more tips. You want to stop talking if you hear objections. So there are cases where you'll be giving your testimony and the opposing party or the opposing party's attorney will scream objection. That means stop talking. Because then the judge is going to turn it over to the lawyers to make some legal arguments about whether or not that information should be given and allowed into the testimony. So if somebody objects to your testimony and the judge, after hearing the arguments from the attorneys, says sustained, that means there's something about the rules that says that specific testimony is not allowed in. So that means you can't answer it. Oftentimes the attorney will skip to the next question. So just be prepared that you might have to skip what you were saying and move on to something else. Overruled means that you can. There's some rule of evidence that says that that testimony is allowed. So in that case, the attorney might repeat the question and you can start from the beginning and give your answer again in totality. If you're not sure what to do, you can always ask the judge, am I allowed to answer? May I answer? And the judge will let you know. Also, if you're confused about what the question is asking, especially if it's a question from the opposing party, it's totally fine to ask the attorney to repeat or clarify or say, I don't understand what you're asking me. Can you please rephrase it? That is completely fine. Just make sure that you're respectful while doing it and don't be argumentative while you're asking for clarification. So some more tips. Examination in the court or the deposition is not a conversation. It's question and answer. So you want to, again, be sure that you're answering the questions that you're asked and not just giving testimony outside of that. You want to be very careful to be accurate in what you're telling, especially when it comes to dates, or important dates and timeline. It's important to be accurate. You don't want to agree with something just to be polite, especially on a cross-examination. Opposing party is not on your side. They are trying to trick you. They're trying to trip you up. They're trying to discount your credibility. So you don't ever want to say yes just because you feel like you need to be polite. You want to make sure that you're answering the question correctly and accurately. Something to keep in mind when you are giving testimony is that releasing records or testifying in one case may affect victims or survivors in future cases. So I'm going to give an example. Again, there's a trigger warning because it mentions sexual assault. In a county with only one judge, a rape crisis center advocate agrees to testify as a fact witness about Valerie's sexual assault and as an expert witness about delayed reporting. So in this situation, what will the judge expect the next time she hears a sexual violence case? In the judge's mind, they'll still have the information that you testify to about delayed reporting, about this specific sexual assault, and that will be useful in future cases and may mean that you don't have to testify in every case because you're educating the judge on these topics, which may be useful in the future. All right, so now we're going to transition to a conversation about ethics, or the unauthorized practice of law. So what can you do as an advocate? Non-attorney advocates can provide victims with basic information about the existence of legal rights and remedies. They can provide victims with basic information about the manner in which judicial proceedings are conducted. They can assist a victim to prepare a legal pleading, legal documents on her own behalf by defining unfamiliar terms on a form, explaining where on a form the victim is to provide certain information, and if necessary, transcribing or otherwise recording the victim's own words verbatim. And an advocate can also sit with a victim at trial table if permitted by the court. An advocate cannot provide advice relating to a victim's rights or remedies, including suggesting the pursuit of a particular remedy. Advocates cannot provide information about the legal aspects of judicial proceedings. For example, how to present a case, how to call witnesses, how to introduce evidence. An advocate can't use their own language in preparing or filling out a form, pleadings, or other legal documents. And the advocate cannot engage in advocacy before any governmental representative on behalf of an individual victim. All right, so that is all I have for you today. If you have any questions, feel free to put them in the chat, or I can put my email in the chat as well. Feel free to reach out to me directly. And then we've included MCASA's line and the Sexual Assault Legal Institute's line, main phone line. If you have a client who needs legal representation related to a sexual assault, we can potentially provide that. So feel free to reach out.
All right, friends, thank you so much for sticking with us through that video. If you have any questions, please feel free to put those in the chat. And we will connect those questions to one of our Sexual Assault Legal Institute attorneys, and they will answer them. Alyssa will send that out in the daily email for the Sexual Assault Victim Advocate training. So we are going to transition into the next part of this presentation. And I am glad to introduce, as always, one of my colleagues at the Sexual Assault Legal Institute, Juan Luis. He is our senior legal advocate, has been with MCASA for a long time, expert in working with clients. So Juan Luis, I'm turning it over to you. Thanks for being with us today.
Hello?
Yeah,
Can you
we
hear
can
me?
hear you. Yeah, we can hear you great.
Yes. But you can only see my camera right now, right? I need to share my screen.
Correct. Correct. We can only see
And
your screen.
how about now?
Yeah,
Are
we
you
can see your PowerPoint perfect.
okay? Great. Um, just a moment, please. Okay. Well, good morning. Uh, my name is Juan Luis Young. I'm senior legal advocate with SALI, or Sexual Assault Legal Institute, and like you all heard, we are the legal arm of the Maryland Coalition Against Sexual Assault. We provide services to survivors. So I work for a team of lawyers that provide a lot of consultations and representation to survivors. Um, and I'm senior legal advocate. I manage our team of legal advocates who we're we're assistant and like we're legal assistants, and we're also victim advocates. We help our attorneys and our clients, our survivors throughout the case. Um, my team are the first point of contact with our office when somebody reaches out to Sally for services, or when they're referred to us. They will first reach one of our advocates, and we conduct the intake process to get information about new cases, to get people help with one of our attorneys. And we do a lot of translation and interpretation. Most of us also speak Spanish, and uh, well, whatever it is that our office that needs to be done to help keep our law services, our legal services running. Um, a little bit of uh, data tracking and reporting for our funders as well. So today I'm going to be talking about safety planning, risk assessment, cyber stalking. This is part of the services we provide. Part of our intake process with new clients is um, talking about safety planning with survivors. Um, it is something, of course, extremely important. We need our survivors and our clients to be safe as much as possible for them to even be able to access legal services or any kind of help. Um, so yeah, as I go into the presentation, into the slides, I'm going to be uh, sharing different lists of questions um, and ideas that we want to be thinking about as we discuss safety concerns with people. I just want to say that it's not like safety planning conversations with survivors are not me reading off of these lists. It's more um, things that I keep in mind as I explore their situation, as we talk about their situation. I try to make it more of a personalized conversation in each case based on what I have learned about someone's situation, because we do this after we've done a in-depth interview about the case. So I will already know a lot of the answers to these questions, or I will have enough information to word it in a way that is more relevant to their lives. Um, so I just wanted to say that before we start showing different things. Um, so first of all, what even is safety planning? I have this definition from the National Network to End Domestic Violence. A safety plan is a survivor's individualized plan developed in partnership with an advocate that focuses on strategies for staying safe. It is typically used with survivors of domestic violence, sexual assault, dating violence, and stalking. And in creating a safety plan, advocates discuss the unique needs and circumstances of individual victims. Um, I also want to mention that safety plan, um, this is the specific meaning of safety plan in the area of working with survivors. Um, but they also have safety plans that are specific to the area in the mental health field for people at risk of self-harm and suicidal ideation. In this case, we're more trying to help people manage their risk from external threats to their safety, where someone else may be trying to do something to them. And the definition I have here is about is from a domestic violence organization, but a lot of this will apply almost identically to many of our cases. But we also have things outside of the domestic sphere. So this is safety planning in this sense is something that we do regularly as part of our intakes. Typically at the end after we've done an in-depth discussion, but if necessary, that can happen at any point in the process, before, during, and after the intake interviews, and at any point later on. So whenever somebody needs assistance with that, we're able to have that discussion. Now, when safety planning, what is our objective? Why do we do that? Reduce risk of further harm. Basically, our goal is to reduce the risk. We're limited in what we're able to do. We're not physically in someone's home and able to check all the possible dangers, check all their windows and their doors, put away and lock away any knives or anything like that. We just do the best that we can through the phone from our desk to give people some ideas about how to make themselves safe. We can try to get them they can take inventory of the situation, and they can think about their risks, and they can think about their resources. Unfortunately, safety planning and the way that we do it is not ultimately a guarantee of safety. It's because we're not physically there to do that. But the idea is to improve the situation as best as we can. So some of the things that we do is we try to identify individual risk factors. We will talk about, what are their immediate surroundings. We will talk about their relationship with the perpetrator, and individual. I'm sorry, I don't know if my slide got messed up here. Maybe it did. There we go. Their individual risk factors may have to do with, what is this someone who is a minor? Is this someone who is a foreign citizen? Is it someone who has access to a lot of resources, or are they poor? Any number of things can play into what are somebody's risk factors. So we want to also increase protective factors. What are their strengths in their safety situation? Do they have access to a support network, friends or family? Do they have access to transportation? Do they have a car or other form of transportation? Are they able to get to safety? Do they have exit routes from their home or their workplace or wherever they may be in danger? These are, we will want to, during that discussion, get someone to think about these things and what are their protective factors, what can they do to increase that or to rely on that more effectively, and reduce stress. That's another important objective. Stress can seriously harm someone's health and their ability to make decisions and function properly. So when by thinking about the options and planning for things ahead of time, that can be very helpful. Hopefully, the idea is to reduce uncertainty and anxiety and stress by having a sense of what can we do, or we meaning the survivor, what can someone do if this thing happens, or if the perpetrator, if they see them at the bus stop, or whatever it may be. Seek empowerment for survivors. Um, we want survivors to feel that they're in control of their safety as much as possible, to reclaim some sense of power and agency over their situation, um, because nobody wants to feel like a victim. The hope is that thinking about what is in our control to do, that can be empowering. So what do we do? In our experience, and in my experience, safety planning is most effective to do as a conversation in collaboration with a survivor. I have some ideas. I try to bring um, empathy. I try to bring my experience from talking to other survivors, my knowledge of this person's situation from what they have told me. And I try to be creative depending on what their exact situation is and what they tell me. But every time, so what I'm trying to say is it's not a one size fits all. Every time we get to safety planning, it's going to be a personalized conversation um, with a different person. They have their unique situation and their unique circumstances. So every time, every safety plan will need to be specifically tailored to that individual person's their needs and their circumstances. Um, it can be depending on how long the conversation is and how much information we're discussing. It can be helpful for someone to take notes and write out a whole plan. Sometimes all they need is just for us to email a list of different tips. We have a list of very basic outline of some things to think about when thinking about safety planning. Every time it will be different. Sometimes the conversation will be very brief. Um, Frankly, sometimes the survivor doesn't really have any concerns in some of our cases. Sometimes they, in that case, it will be just a brief reminder and refresher about online safety and picking their privacy settings on different applications, or it can be a long, detailed discussion about specific plans, what uh, what their environment looks like in their home, the entrances and exits, logistics. It can be anywhere in between those two extremes. Um, but it will start with a conversation. I will ask someone if they have any concerns about their safety. I will listen to their answer and go from there. Ask if there's any specific concern, and I will try to respond with questions primarily and suggestions to see how they can best respond to this or that risk. Um, Sometimes there may be also a specific concern that I have based on something we discussed previously during our interview. So I'll make sure to bring that up during this discussion to make sure that they have the ability to handle that situation. Um, but basically, I try to keep in mind that it's their life. They're the expert when it comes to their surroundings and their relationship with the abuser. If they have a intimate relationship or some kind of personal relationship. Um, yeah, I'm not the expert. I'm able to provide some outside perspective, ask some questions, offer some ideas. to think about their situation, and hopefully that can be helpful. But I try to approach this conversation with some humility that I know I'm not the expert and I cannot be the expert on how to plan for someone else's life and every aspect of their situation. Um, Especially in the case where the abuser is someone that they know intimately. I can't possibly fully understand all the intricacies of that dynamic in that relationship. So they will know better than anyone could, how this person's character is and how they might react to different things. When I have this conversation about safety planning, the survivor is in charge, and I'm just here to try to offer some suggestions, try to ask the right questions. Um, just a moment, please. So there's a I'm gonna in this page show different um, pictures of different types of settings where we may need to or that we may need to plan for. Um, Sexual assault may happen in a bunch of different types of different scenarios. Um, and the list I have here is not um, exhaustive. There will be exceptions. There will be different circumstances in each case. But um, so here are some examples of places where this might happen. This picture is showing what looks like a school campus, um, a school or a university. So a lot of times the abuse can happen in some kind of education environment. It may be the perpetrator may be a classmate, somebody if it's a residential college, it could be somebody in the friend group, somebody who lives in the same dorm building. Um, and this type of setting can have its own set of challenges and and its own type of resources. Um, on the one hand, yeah, it can very much hurt someone's access to education, um, but the unique resources there would be for like teachers, counselors, school resource officers when you're in the K through 12 education. Um, Sometimes people can also rely on uh, friends, classmates, or friends. But depending on that specific case, we can talk about how to use some of these resources on campus to get someone to meet their safety goals. Um, Another common scenario, these are different pictures showing different types of workplaces. Um, Workplace sexual harassment, unfortunately, is very common. I've worked with a lot of um, victims, especially in our undocumented populations. A lot of times the um, a lot of times the perpetrator will be a boss or a supervisor. Not necessarily, but they get they people feel that they can take advantage of undocumented workers a lot, unfortunately, but not exclusively. Also, it also happens to other people. Um, and there's a lot of variation between different workplaces, but um, resources specific to the workplace can be uh, a supervisor, a trusted supervisor, or a human resources department. Then we have a picture of a living room. This is the home environment. A lot of time, the abuser may be a spouse or a partner. Um, Unfortunately, in a lot of our cases, a parent. Um, we work with a lot of um, child survivors, so that can happen, and the the immediate physical safety is a urgent concern in that type of situation. Um, Often for our clients, when by the time they call us, they have already either moved to a shelter, escaped to a shelter temporarily, or filed for some legal action, a protective or peace order, a protective order to have the abuser removed from the home. But if not, that immediate physical safety will be a uh, very urgent, very critical. Um, Now, depending on who the abuser is and their character and their relationship with the victim, we have to worry about possible retaliation and think about how the victim can protect themselves without raising suspicions, how they have to be discreet if they're going to seek help. And resources to consider in that type of situation can include other members of the household, the family, um, depending on the type of home. It can be housemates, roommates, a trusted neighbor. In cases of where there's risk of violence, sometimes law enforcement may be the only effective option for some survivors. They may need to try to have that save their emergency numbers saved on speed dial or something like that. And question mark, because it can happen, everywhere else, anywhere else. Uh, there's definitely some common situations that we see, some patterns and types of scenarios, but every time we have this conversation, it will be uniquely different depending on the person's circumstances and the specific details of their situation. So generally speaking, when we think about safety planning with survivors, we want to keep in mind the context of where the abuse is coming from. It can vary widely. It can be an intimate partner. It can be um, not intimate at all. It can be a first or second date, someone they're just getting to know. It can be child sexual abuse by a family member or by a teacher, or it can be a complete stranger, which it has its own challenges. Sometimes it's a known stranger, someone they recognize from the neighborhood, from class, from the bus stop. Uh, so whatever the case, if it's somebody who's known, we want to think about how to be safe in that lecture hall or in that class, at that bus stop or wherever they run into the abuser. Um, so whatever the case, we will have to troubleshoot for different types of issues and use our best judgment and understanding of the situation. Um, in our office, in our process, we talk about safety planning after we have had towards the end of our intake interview process. So we've spent a good while learning about the case and learning about the situation. We have a good sense of the whole picture of the case. By that point, we have as much information as we're going to get in a couple of hours of knowing someone over the phone. So at that point, we can try to help someone troubleshoot for these different possible issues and try to tailor the conversation to their specific needs. Um, we want to be aware that survivors may already have connected with different resources like counselors, police, human resources, department at work, doctors, advocates, lawyers. Um, and if they haven't, we may be able to encourage them to make these connections in their different in whatever setting, as that they may need support. Maybe they already had a safety planning session with an advocate or some other professional, or maybe they have thought about all this stuff already on their own. So we can ask them about it, what they have thought, what they have discussed with someone else, Do they have any new concerns since they had that conversation, any new issues that came up? And we can try to supplement what they already worked out, or what steps they have taken. Um, Now, when I keep repeating things to this effect, but when thinking about somebody else's safety, it's important to keep in mind how they're not, it's not for ourselves. It's not for me. So we have to be aware of the ways that this person may be different from us. And this can affect what their options will look like. So we're going to get into the idea of intersectionality, or taking into consideration how different backgrounds and identities and different statuses can affect someone's experience and how they may be treated differently. So, um, I have a list on the slide of different categories, or let's say axes along which people can differ, um, that may affect their options depending on where, the geographic area that you work with, or the type of population that you work with. You may come into contact with survivors from different types of backgrounds. Um, a lot of times people who are members of a minority group or some lower status group, they may face serious barriers to get help. Um, People who come from higher status groups may face less barriers to get help. Um, One example I see often is our Hispanic immigrant clients. Most of them are first generation in the country. They may not have legal status, and they may speak very limited English, if at all. So in that situation, if somebody's a victim of a crime, they're away from their home country. They don't speak the language that the police speak. They don't speak the language that the courts speak. That will make it very, very hard to ask for help and to receive help. And then maybe they live in a small immigrant community or neighborhood where everybody knows each other. Everybody that they can talk to, everybody that speaks their language, they all know each other. And maybe they all have some connection to their abuser, or they know who he is. They see him. Maybe he is well known and maybe well respected in the community. These types of things, as they stack, they can make it even harder, for the survivor to speak out. Um, a lot of the time, the perpetrator will also be a member in the same community. Um, and this applies to small and isolated communities of all kinds. It's not just immigrants that don't speak English, as I have on the slide. There's also, for example, people from rural areas, isolated rural communities, um, may have barriers to access, um, to even ask for help. People from certain communities of color or sexual minorities might feel unsafe around law enforcement or police. They may have some distrust, towards the state. Some people may fear they're, less likely to be believed as victims because of their race or sex or sexual orientation. Um, on the other hand, economic status can also be critical. Um, for example, a survivor with very little or with no income will have a very hard time leaving their abuser if they depend on the abuser financially. Um, they may have a hard time leaving a job where they're being sexually harassed at work if they can't, um, afford to lose that income. Someone maybe can't even afford to cover their cell phone bill so that they can call someone for help, or call our office for a legal consultation. Um, all these things, play into someone's options. Um, and safety, of course, is more than just avoiding physical violence. Um, that can be harder to access for some. So we may all, in theory, be able to use the same resources, but that will be harder to do in a second language, or harder to do after you've worked 2 shifts for 2 different jobs, or barely surviving homelessness. Now, I also mentioned that being belonging to a higher status group, or coming from some form of uh, privilege, can sometimes benefit someone. This is um, kind of obvious, but we don't talk about this side of when we talk about intersectionality. We don't often talk about this side of it. Survivors who don't struggle with English will feel a lot more comfortable talking to law enforcement. Someone who has a stable middle class income will be able to move away from to their abuser, to move to a different neighborhood or a different city for their safety. Financially, they can afford that. To give you a personal example, I speak Spanish. I'm a first generation immigrant. People don't see me as white in this country. But that intersects with my middle class background. I where I grew up in Peru, I grew up middle class. I went to college here, and I can uh, speak English like someone that went to college here. Um, I have an income. I can afford to sign a lease for a place to live if I needed to. I can afford to fly even. I can afford to go see my family in Peru. Um, that's a huge privilege. On the other hand, I have the minor disadvantage because of my appearance. When I fly to visit my family in Peru, sometimes I get randomly selected more often than some people who get asked more questions by immigration officers and have my bags searched more than some people, which is a tiny little insignificant example, but I hope it illustrates how my different identities and characteristics and experiences um, shape the overall experience of what I have access to and what I have to deal with. Um, and I'm sure we can think of different examples from everyone's personal experiences and everyone's identities of how they may have access to different advantages and disadvantages. Um, Now, the last thing I want to say about intersectionality is you can't possibly know everything about every type of person that exists. Um, you can't possibly have all of the knowledge about someone's culture and religion and background, and know all the right information about how their life is. But the important thing is to approach the discussion with an open mind and some humility. Be aware of your biases and your privilege, and try to be mindful of that, of where you're coming from, and not assume things about people. Um, there's a lot of life experiences that I can't fully relate to or understand, but I can try to listen to their situation and try to offer resources to help them figure out the how to respond to their situation and make it so that they are okay. They're the expert, like I've been saying. Now, I want to talk about risk assessment. Risk assessment is when we analyze someone's situation to look for potential hazards, and we try to anticipate what could happen if something occurs. So I have some questions on the slide. These are not necessarily things that I will go through the list asking one by one, but things that can be helpful to discuss with a client to help brainstorm for possible scenarios. For example, Are you safe now? Is it safe to contact you? This lets you have a baseline sense of their safety situation. The first time someone contacts our office, we we ask if the number that they're calling us from is safe for us to call them back at that number. Is it safe for them if we leave voice messages? And is it safe to say that we're calling from Sally or the Sexual Assault Legal Institute when somebody answers? And this is to check that they wouldn't be put in at any additional risk if someone else has access to their phone, if someone else were to take their calls or answer their messages. We also ask, is it safe to contact via mail? We want to know if someone is safe, if it's safe for someone to receive letters or documents about their case without the risk that an abuser in the same home, in the same household, can read it and they may be exposed to some retaliation. Or maybe not the abuser, maybe someone else in the household who happens to know the abuser and might want to feed them information. Who knows? Now, the other questions on the slide will give us more information about different things to explore the safety landscape of someone's situation. We have the next three questions about contact, actual or potential contact with the perpetrator, either directly or through friends or family. Have you seen them? Any contact? Have they contacted friends or family? One can also try to get a sense of someone's life routines and what times and places they may potentially run into their perpetrator or their abuser. Does the perpetrator know where you live? Do they know where you work, where you go to school, where you go to the gym, whatever it may be? So these questions help us get a sense of what are the different risks and for each possible. Depending on the answer, we can try to help someone come up with plans for each situation. If the answer is that they see the person in class, then we can follow that, go down that path, asking questions about if they know anyone else in class, is there someone that they can go to for help, and we can go into as much detail as necessary about the classroom, the classmates, the teachers, the building, the whatever it may be. Now, has the perpetrator stalked you, your friends, your family? Are there times of day or places where you feel more or less safe? These questions will give us more information, and then we can try to explore options. Like, can they go grocery shopping at a different store than they usually go, so that the perpetrator won't know to follow them? Can they go to a different bank to deposit their checks, or to a different branch? Can they do whatever it is they need to do at a different time of day so the abuser can't predict their normal routine and try to intercept them? Are they able to bring a friend or a family member? The person, the survivor, can try to come up with different possible answers to each different issue. And a lot of the time people do on their own, but we can try to help them think of different options and different resources. Now, I have here a few tips for the specific scenario where the person is at home and under attack from someone in their home. This can come up especially in cases where the perpetrator lives in the same home as the survivor. So if you're at home and you're under threat or attack, stay away from kitchen or places with weapons, small spaces where you could be trapped. Go to a room with a door or window to escape, room with a phone and a locking door. And call 911, get the person's information, will provide information about where you are and try to get information about who you spoke with. These are, things that may be obvious, but one thing I was told about the first tip about kitchen or places with weapons, people's first instinct when they're under attack can be, well, first to get away from the threat, but sometimes they can try to go looking for a knife or something they can use as a weapon that that could also backfire. Those things could be used against them. If they go hide somewhere to bathroom or a closet or somewhere where they can shut a door, put a door between themselves and the threat, they can end up trapped in there and they have no way out. Um, and they maybe don't have access to any way to call for help while they're trapped in there. So during safety planning, I try to get people to mentally take inventory of their physical environment, their surroundings at home, to think if something happened, where would they be safest? Um, so that they don't default to doing something and end up trapped. Um, Now, other things to consider when it comes to being safe at home: becoming familiar with local safe places outside of the home in the area. That can include a neighbor, a friend or family member that lives close by, the local church, the police station, the crisis center or domestic violence shelter. It's probably a good idea to memorize the route to the nearest safe place. Change the locks, check locks on windows, security code, change security code. This can be this would apply if the perpetrator lives in the same residence and they have moved out or they've been removed because of a protective order. That would be a good time to change the locks to make sure that they can't get back in. Confirm you have sufficient functional outdoor lighting. This will depend on the type of housing, but having outdoor lights can also be a deterrent. Maybe motion activated lights can make the survivor think twice about doing anything, or sorry, alert the survivor that something's happening, make the perpetrator think twice about doing anything if they think that someone could see them as they are approaching. Of course, this will not apply inside of a apartment complex, but in some single family homes that will be, um, or even townhomes, that can be very doable and very useful. Um, Make an escape plan. That's related to the first point there of becoming familiar with the local safe places. Um, we can encourage the survivor to think about where would they go if they needed to escape and to make a plan for that. And if they have children, they can of old enough to learn this, they can make sure the children know the plan and that they have practiced it, that they know how to get to a safe location. Prepare an escape bag. When a survivor is thinking about leaving an abuser in the home, or they're anticipating that they could be at risk of something happening, it can be good to pack a bag with any important things that they might need if they had to leave quickly. So they can pack their escape bag with clothes for a few days, any prescription medications, any important documents, ID, insurance cards, uh, medical documents, passports, any bank information that they might need. And this bag, they can store it somewhere safe in the house where they can just grab it on their way out, or they can give it to someone else for safekeeping. They can keep it at the neighbor's house or give it to a friend or a relative so that they can have access to that if they need to leave the house. Trusted neighbors. If someone has a good relationship with the neighbors, that can be a very, very powerful resource. If anything happens. Now, another thing people can do is to prepare an excuse to ahead of time to be able to leave the house, to come up with different explanations for why they need to leave the house. For example, oh, I need to go to the store to get this, and depending on what time of the day it is, they can, or what the situation is, they can tell the perpetrator this excuse, and then they leave and escape to safety, um, without raising any suspicion because they have a reasonable explanation. Another thing I've read is that, for example, a survivor can choose to. Well, actually, I've also seen this in clients that I've had. A survivor can choose to, instead of sleep in their bedroom in the house, they can sleep in a public area of the house, where there could be potentially witnesses, eyewitnesses, or people who can hear something if a perpetrator were to do something to them there. For example, if they're sleeping in the living room, or they can hang bells outside of their door that would alert anyone if someone was opening their door. Worst case scenario, I've talked to someone who basically was able to barricade herself inside of a room. Obviously, this is not the first thing that I would want a survivor to do, but in case of emergency, it can be done. Someone who put chairs and desks and tables up against the door and blocking the handle so that the abuser on the other side was not able to come into the room, and she was able to call for help. Now, outside of the home, things that we can think about: changing regular travel habits. So that would be taking different routes or different times of day. That will make it harder for a abuser to intercept their victim, and to anticipate where they're going to be. Travel with others whenever possible. This is something that that's the first thing that people think about usually. It really helps people feel safe whenever that's an available option. Alternate where banking, grocery shopping, or other routine activities are done. Yeah, self-explanatory. I mentioned this earlier also, but it'll make someone less predictable, someone's moves less predictable. Cancel any shared bank or credit card accounts with the abuser. Just use cash if possible. If someone has a joint credit card or some kind of financial account with the abuser, if they use that debit card or credit card, that will inadvertently share information with the abuser about where they're shopping, where they're going to the store. It might tell the abuser about the location, so that one can be very important. In general, anything someone can do to make their moves less predictable can help. Sorry, one moment. Switching up schedules, changing habits and routines, whatever is available for the survivor, that can be very helpful. Now, the workplace. In the workplace, we have these other types of tips and things that we can think about as options. Providing a picture of the perpetrator to security or to work colleagues, so that people, if they see them, they know that this person could not be here, or they know to alert the survivor. Now, talking to a supervisor, depending on the type of workplace, this may be applicable. The example on the slide says to remove the person's name or picture from the company website. Some other types of workplaces, a survivor can help by moving the victim to a different work area or putting them in a team with someone that they trust and that they feel safe and protected with. Um, we also have request security walk with you. That's related to the buddy system. People feel more safe if they have someone else with them. Um, if there's not security staff, it can be a coworker that can help as well. Save any voice messages the perpetrator leaves at work. That can be helpful for um, evidence in case of violations of protective orders or for other legal action potentially. Um, Now, for the campus setting, different unique things, unique tips that we might want to take into account. For example, take different routes to class. That's a variation on the theme from earlier. Know your resources on campus and off campus. So who would the survivor be able to contact if they need help? They should know campus health center, police station, their sexual assault crisis center, any counseling center on campus. Uh, these are all things that can be helpful to know how to contact if anything comes up. Um, and if there's concerns about privacy, the people can also look into similar services off campus in the surrounding city or town or county or the surrounding community. Now, campus security, this will vary depending on the school, but some campuses have services like a shuttle ride from the home from the library if people are studying late at night, or they will provide they will escort people to their dorms if needed. Um, Request a schedule or housing change. This people can try to do that. Survivors can try to talk to a dean or some other school administrator. Um, have backup plans. Think about a plan B for potential bad situations. Do they know their campus address? Do they have that memorized? Do they carry cash in case something happens to their phone or their card? Um, if they were to lose their phone, do they know anyone's number that they could call? Do they know anyone's number from memory? Um, if they have a car, do they have a spare key somewhere? Um, Now, be mindful of victim blaming. This is unfortunately part of um, the social culture and the on college campuses. Uh, Partying and alcohol are big, and on the one hand, it's definitely helpful to know your limits when it comes to drinking, so you can tell if something feels off. You can tell if you may have been drugged. Um, Unfortunately, we have seen many cases of people that where someone has slipped something in their drink to take advantage of them. So certainly, protect your drink is um, there's something to it. It's coming from a well-meaning place. On the other hand, the culture of victim blaming can sometimes take advantage of this, and uh, abusers in legal proceedings sometimes can use the fact that someone um, was drinking or using drugs or has ever done that to try to smear the victim's character and make them seem like they're not worthy of sympathy or that they're not the perfect victim. Um, so for people on campuses, it can be helpful to try to be mindful of these things and try to be um, discerning in terms of who they have as part of their social circles, so that they're um, well not exposing themselves or contributing to um, that type of that type of mentality of blaming the victim. Um, Now, some tips some tips for children. Children, unfortunately, are caught up in these situations at times. So there's some things that we can um, keep in mind as we think about safety with parents of young children. Teach them how to call 911 and give their phone and address to police. Teach them who to call for help. Outside of law enforcement, that can be a family member or a friend. Um, Make sure they know who to go to if they see the perpetrator at school. Um, it may be a teacher or some other staff member that they trust. Make sure the school knows not to give their name or phone number to anyone, the child or parents. Um, yeah, sometimes we have that where the um, perpetrator and victim have a child in common, and the perpetrator may try to go to school and gain access to the child that way. Um, Now, for preparing for an emergency, some things that people can do: obtain a cell phone that you keep charging on your person at all times, if possible. Um, if possible, keep chargers at work, keep chargers in the car, chargers at home, chargers in your bag that you carry around. Um, have emergency contacts pre-programmed. Um, Memorize some emergency numbers and important phone numbers in case you lose cell phone access. Um, so have emergency contacts, but also don't depend on them completely in case something goes wrong. And the secret word phrase is something that people can use in case of crisis. Um, they can have this conversation beforehand in preparation with a someone that they trust. In case of a crisis, they can call someone and say the secret word or phrase, and that way they discreetly let someone know that something is happening and that they need to call the police for the survivor. Uh, so that's another thing that people can do. Now, emotional safety is another important component to this. Um, During these conversations with survivors, one can get a sense of someone's social safety net and their support network. So important information to know can include who else knows about the assault, who can you reach out to in a crisis. We've talked about um, some of the ways that other people can be very helpful for safety. So in addition to the buddy system for physical safety, it can be the emotional support can be also invaluable. And then there's also referring to their local rape crisis center for counseling and 24/7 crisis support. Um, the counseling services there and other programs they may have can help address the physiological, the neurobiological effects of trauma. Um, so sometimes working on somatic practices can be part of, maintaining physical and mental well-being for survivors and part of their healing process. Um, that's something that is outside of my um, area of expertise, but um, something that counselors can offer help with sometimes. Um, Now, I want to talk a little bit about the cyber part, the um, cyber stalking and online safety. So um, I'm going to talk about some of the tips or questions that I use when talking about safety planning with survivors. Um, First, a definition: what is stalking? In Maryland, stalking is a crime defined as a persistent and malicious pattern of approaching or pursuing someone in order to make the person feel afraid that they or someone else will suffer serious bodily injury, assault, rape, or sexual offense, false imprisonment or death, or the stalker intends to cause, knows, or should know that such conduct will cause serious emotional distress to another person. Um, And cyberstalking is unwanted advances or threatening behavior directed towards someone using the internet or other forms of online communications. So it's severe, it's pretty common. 21% of women ages 18 to 29 report being sexually harassed online, and 53% of women in that same age range say that someone has sent them explicit images without their consent. Um, so stalking on social media, something that survivors encounter not uncommonly, is people may be sending them unexpected friend requests from random profiles. People can do that to track someone's updates and statuses. Someone trying to keep tabs on their check-ins in physical locations on social media, sending harassing or threatening messages, making fake profiles to track someone, posting anonymous abuse, posting false or defamatory information, posting nude images or other sexual content. So now here's some of the questions or tips that we might want to keep in mind as we talk about these issues with the survivor. Do they have access? Does the perpetrator have access? Or know your phone number or email address? Do they know any of your passwords? Do you even have social media accounts? That's the first question. Do you have any shared social media accounts with the perpetrator? Sometimes that can happen in intimate partner relationships. Are you friends with or connected with the perpetrator in some of these social media platforms? And is anyone in your network friends with the perpetrator? This can come into play with, for example, Facebook will let friends of friends sometimes have access to some information, even if um, otherwise not connected people, otherwise like strangers would not have access to some information. Has the perpetrator or their friends contacted you since the assault? Have they posted anything about you online, the perpetrator or his friends? Have you reviewed your privacy settings since the assault? Can you adjust that to make your personal information more secure? Yeah, I'm gonna now on the next slide, I have some um, specific um, social media services, but what I want to say in terms of privacy settings is um, it may be that, well, like I mentioned, friends of friends may have access to some information even if they're not connected to the abuser, so it can be helpful to think about that um, in case someone else is feeding potentially information also to an abuser. So you may be friends with someone who is not the abuser. They have access to your information. They may be able to grab screenshots and pass it along or give updates. So thinking about your social network generally can be important for safety. Um, so these are some questions that I may bring up in the conversation or that I may keep in mind. I may already know the answers to some of these. So it's not like I go point by point asking each question. Um, but even if someone feels perfectly safe with everything, these are even if someone is not interested in having a extended conversation about safety planning, I do ask them about these things because um, they can make them less safe even if they're currently not worried about their safety. Um, so in order to keep them that way and not interested in having a conversation about safety planning, I try to make people think about if they have any weaknesses in terms of their social media presence or internet use otherwise. Um, so I have here some general safety tips for people when using the internet. Do not share information about your activities, your home, your work, your school, childcare, where you're going shopping, your social plans, how you're getting there, transportation, any aspect of location and habits. Um, not accept requests to connect with anyone you don't recognize. Um, I've seen people um, I've seen people doing that to gain access to information. Block the perpetrator on any shared platforms. Block any friends, family, or others who might sympathize with the perpetrator. Um, Consider removing your picture from profiles and using a nondescript image instead. Um, and review privacy and security settings. Take time to review how your profile appears to you, to your friends, and to the public. Um, it's probably best to assume any information that is shared online on social media will could be always accessible by anyone. Um, Another thing is a lot of people use Snapchat. Snapchat is very popular, especially with people under a certain age. It by default it shares location with friends, so that can be changed in privacy settings. That's something that I let people know about. Be Real. I haven't used that myself, but I know it's um, also popular, and it also by default shares location. Um, so just things to keep in mind when thinking about safely using the internet and these technologies. So things that people can do, changing their passwords so that people can't break into their accounts. Um, on shared devices in the home, use private browsing, incognito mode or private browsing or whatever it may be called, so that they don't leave a trace on their device that they share with the abuser if they have been looking up how to access help or how to access services. Delete old accounts if it's just to minimize the risk of, one less place where they can be harassed or contacted. Set boundaries with family and friends about tagging. So even if someone is doing everything right and not sharing any information about themselves, it can happen that friends or family, they have their um, social media settings such that anyone can see whatever they upload. It can happen that the survivor is out with friends, out with family. Someone takes a group photo and uploads it to a social media platform, and anyone can see that. Um, that may give their abuser information about what the survivor is doing, where they're at, um, and it can expose someone to potentially danger in that way. Um, yeah, preserving safety and privacy with friends and family. Um, so not only the settings on the app itself, but also the conversation with people about what may be more or less safe for someone. Not opening suspicious messages or emails. That can be, um, people can send phishing messages to get someone to enter their password in a page that looks legitimately like their email account or something like that, and may accidentally um, give someone else access to their accounts, or may accidentally um, disclose some aspect of their online safety. Um, Keep track of any unwanted calls, texts, messages, and voicemail from the perpetrator. Again, this can be for evidence, um, for some type of legal action potentially. Um, and yeah, that was all the things I wanted to share in terms of what we think about when we're talking about safety planning. So in summary, consider the identities of the people that you're working with and prioritize their immediate safety. create a detailed plan specific to them and using support and any resources that they have, and being mindful of the pitfalls, the exposure from social media and the internet. Clients can take notes, we can review the final plan together, and we can email them a list of emergency contacts and resources and general outline of things to keep in mind and think about. So yeah, I think that's all. Thank you for your time. My information is on the slide if anyone needs to reach out or follow up about anything. And I will pass it back. Thank you and have a nice rest of the day.
Thank you. Yeah, that was a great presentation. So if anyone has any questions for Juan Luis, or if anyone has any questions about the content that was presented before Juan Luis, feel free to put that in the chat and I'll monitor the chat, collect any questions and send that out to everyone once we have responses for the questions. I've also put the anonymous evaluation link into the chat. We greatly appreciate all feedback as we're constantly striving to improve. Additionally, if you're seeking a certificate of attendance or a certificate for CEU credits, you must complete the evaluation form. Once you complete the evaluation form, you'll receive access to the certificate request form. And if you have any questions about accessing the forms, if you have any difficulties, feel free to email me. I'll be sending out a follow-up email later today with a copy of today's recording and the PowerPoint slides used in the presentation, as well as a copy of as well as a link to the evaluation form. So if you have any questions, feel free to email me before then or email me and respond to that email. Thank you all again for coming, and we hope to see you tomorrow.